Hi, everyone. My name is Rachel Marks, and I'm the Director of Education here at SunRay. We help thousands of general contractors, subcontractors, and suppliers secure their lien and bond claim rights. SunRay secures over $10 billion annually. Today's webinar is conducted by the incredible Josh Quinter, a New Jersey construction lien law guru. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I'd like to introduce the fabulous Josh Quinter.
Thank you, Rachel. Good morning, everyone. Thank you for joining us this morning. We're going to, as Rachel suggested, cover the methodology, if you will, about how to make sure you're getting paid on a project when it, as they tend to do from time to time, goes a little sideways. So at the outset, I will tell you that this is designed to be an overview or a primer of sorts. We'll do some programming later in the year that will dive some of these topics a little deeper, but this is designed to give you, in this case, pun intended, a toolbox to go to in terms of what you can do if you're not getting paid. So without further ado, if you have any questions, go to the chat box. You can use that and submit them. And I'll do my best to get to them in the 20 or so minutes. And then if we don't get to your question, please feel free to reach out afterwards. I'm happy to have a short conversation to see if we can't get your question answered. Some threshold questions you want to consider when you're running into a payment dispute. And there's two times where I encourage people to think about getting paid. Number one, you really should be doing it as you're forming your contract on a project. I encourage all clients, it's good to have a sort of a base form contract that you like and that you like to use, but it is never one size fits all. Every project, you should take some time to analyze the specific risk on that project, and you may need to put tweaks here and there in your agreement. The second time is when it becomes apparent you're either not getting paid or you're not going to get paid. And when you get to that demarcation point, you want to sort of start asking these series of questions. Number one, how much is at stake, and are there any possible counterclaims? Why do you care about counterclaims? Because if they can come back at you for something, you may view the case a little bit differently than if it's just a straight pay claim. Everybody knows that the money's probably owed, or some money's probably owed. You might approach it a little bit differently. You want to know what kind of project it is. Is it a public project? Is it a private project? Is it a quasi-public project? You want to know, how's your contract? Is it your contract that you like and you wrote and has some good terms in it? Or did you buy the project knowing that you were going to use somebody else's contract that, as we all know, can be one-sided from time to time? And you want to know what it says specifically as to those provisions that deal with payment. You're going to want to ask yourself, do I have lien rights? Do I have bond rights? Those things often go back to number two, which is the kind of project it is. We'll cover that a little bit this morning. Is there an applicable prompt payment statute? Oftentimes there is, depending on the state you're in. And New Jersey has some prompt pay statutes that may be of value to you. So you want to keep an eye on that. And then the last thing is sort of working through some very practical considerations, some of which most people think of, some of which I have found in my experience people don't really take into consideration when they're sitting at the front end of a payment dispute and maybe talking to a lawyer, maybe thinking about talking to a lawyer to go try to get their money for them. So let's take each of those in kind in the time that we have this morning. The amount at stake in counterclaims. The ROI on a claim matters. I mean, if you don't hear anything else this morning, please make sure you hear that. It really does not make sense to spend, 25 to get 50, or the converse, 50 to get 25. Sometimes you don't know what those ratios are going to be up front, but you want to think through that. There are very few exceptions to that baseline rule because if you can't get your attorney's fees back, or at least most of your attorney's fees back, there's a business consideration in there, a really good counsel is going to spend the time to work through that with you and help you figure that out. The next thing, consider the non-financial elements. There is a time value to money. I have told clients from time to time, hey, look, it's a little less than we want, but 25 grand now is better than 30 grand in 18 months. There's a time value to having it in your hands now. when you get involved in litigation or pay claims, it takes time away from doing what you do well, which is building things and making money. So there's a value to that. And then there's just obviously the pure frustration of having to deal with somebody who you did good work for and you want to get paid and they just don't want to pay you for whatever reason. That can obviously have an impact on your mindset and the way your business runs, and it's a frustration that nobody wants if you don't have to have it. The next thing you want to think about is the work complete and or was it invoiced for? Now you're probably thinking, well, that seems pretty obvious. Why is that in the list? It's in the list because it's so obvious. You'd probably be shocked how many times I've had clients tell me over the years that they're owed, some amount of money, and then you ask for a copy of the invoice and they tell you, well, I never invoiced it. I know I did that much work. Well, it again sounds obvious, but the obligation to pay is not triggered until the invoice is sent out most of the time. So, if you know a pay dispute is coming, put the invoice on the street so that trigger happens. Don't wait, because then the first thing the lawyer is going to say is, well, you got to invoice them, and then we got to wait 30 days, and that can impact some timing things. If your due diligence was not done at the front end when you look at the project, meaning did you look into the owner, did you look into the general contractor, whatever the case may be, do it now. Right, and what you really want to know is there going to be money in the pot at the end of the rainbow when I get there? Because nothing is more frustrating than spending 12 months or 18 months chasing, whatever amount of money it is, and then you get to that point where you have a piece of paper in your hand that says that you're owed the money, and they go, well, I don't know what to tell you, I don't have it. So that kind of relates back up to the first bullet point on ROI. Don't spend 25 or 50 to get zero because you have an assetless entity. You want to know that before you get started as best you can. Analyze possible defenses and counterclaims, and you'll see there I put in understand the difference. The reason is a defense is very different from a counterclaim. If it's a defense and you get a small way into your case and you decide, what, this is too frustrating, this is too expensive, I don't want to do this anymore, you can just walk away. You can discontinue the case and walk away. If there's a counterclaim, however, you can't do that. If the other side has filed a counterclaim and sued you, which in New Jersey often has to be the case if they think they have a counterclaim because it's what we call the entire controversy doctrine, then you can't just walk away. You have to have their permission, because if you walk away from your lawsuit and they still have yours, you're still a defendant. So what are the kind of things that might drive a counterclaim? An allegation that there's defective work, an allegation that you were delayed, an allegation that you owe liquidated damages. So you want to be honest with yourself. Don't bury your head in the sand. It doesn't mean they're right. It doesn't mean that they'll win, but you need to look at it and go, is there a basis on which they might allege that these claims, that they have these claims, and these claims exist? Because if it's coming back at me, whether they win on it or not is inconsequential for the initial evaluation of whether you want to sue, because you may or may not be able to walk away from it at that point. Value of the related to that, the value of the payment claim versus the value of the counterclaim. If you're owed $50,000 and you're picking a fight, and the counterclaim coming back at you is going to be $250,000, and you think there might be some level of validity to that, like I've had clients say to me, yeah, I'm owed money. I also know that I probably didn't do everything exactly right here, so it's probably not everything that's on my invoice. I probably got to give some discounts. Sometimes you get into the realm where you might actually owe them more than they owe you, so be careful. You may not want to pick a fight there. Think through that and make sure. That's not to say you shouldn't go after your money, but it's something to take into consideration. And then the last one is, are there alternative avenues of recovery? Sometimes, there might be a more creative way. I would encourage everyone, if you don't have a valuable team of people around you, which for any construction company owner, in my mind, is a good lawyer, a good accountant, a good bond person, and a good insurance broker, and probably a good person at a bank. those folks ought to be able to come up with other ways you might be able to make up the difference on that money, maybe without having to necessarily go to court and or an alternate theory other than just a straight breach of contract action. Think through the next topic, think through the project type. Identifying whether the project is public or private, it can, and often does, is probably a better way to say it, dictate your remedies. Public jobs, by definition, have public owners and or use public money. Public owners, who are public owners? It's the government, it's quasi-governmental entities. So you may be doing a job for the Department of Corrections, you may be doing a job for the Department of or the Highway Transportation. Could be any state agency, could be a municipality, could be a county. Those are public jobs because the money's basically, at the risk of oversimplification, the money to pay for those jobs is coming from the taxpayer. A private job is exclusively owned and run in the private sector. So those are going to be your private commercial jobs, like, for example, building a shopping center. Maybe you're in residential, you're building homes, but it's all private money and all private entities. And then you have situations that you can bump into from time to time, quasi-public projects, and that sounds a little bit more sophisticated sometimes than it is. And what I mean by that is sometimes you'll bump into a situation where it might be a private entity, but it has a lot of public funding. So an example of that I've bumped into, I've had a couple cases, for example, at Temple University. Temple is an institution that has kind of a weird designation. It gets public money. It kind of is private. It's kind of public. So that could get a little bit more sophisticated in terms of just trying to sort through where you want to categorize that job. So most of, which is to say 98% of them, you're either going to be all public or all private, and it'll be pretty clear to you if you ask a few questions and figure out where the money's coming from and who owns it. So what does that decide, or what does that drive you to? Private projects, you're generally going to be allowed to file a breach of contract action, and you're going to have access to construction liens. I'm seeing payment bonds more on private jobs, but they're still not, all over the place. So sometimes you'll have a bond. Usually it's on really, really big jobs, meaning a lot of money involved. And then on a public job, you have a claim for breach of contract, possibly you have a payment bond claim. And in some instances, depending on the statute, you may have a municipal mechanics lien claim. We'll get into the mechanics of that, no pun intended there, in a minute or two. But in both instances, you may be able to come up, as I said before, with some other creative remedies, depending on the specific facts of your case, and maybe some of the experience levels of the people you're working with. When you go to look at your contract to figure out what your remedies are, what your arguments might be, here are some of the things you want to pause on. Number one, is your contract in writing and signed, or is it oral? A question I get all the time is, if I have a written contract and it's not signed by the other side, is it enforceable? The answer is yes. Most of the time. It's a little bit of a fact-sensitive analysis, but just because both sides didn't sign the same copy of the contract, meaning their signatures are literally on the same page, they signed it sitting together across the table, that's not what has to happen for it to be enforceable. Your proofs become different if you have an oral versus a written contract, which is why you want to know that at the start. The next thing you're going to want to do, obviously, is look at the payment clauses in your contracts, because that sets the outer boundaries. You're looking for what the conditions preceded to payment are. You want to know about the timing. Are you net 14? Are you net 30? Those kinds of things. And then you're going to look at your what we call the payment clause part of the contract, which is it pay if paid? Is it pay when paid? Is it none of those? That's an important thing, because, for example, pay if paid language is interpreted to mean that if the people that have to pay you didn't get paid, they don't have to pay you. Pay when paid means that it only allows them to delay it for a reasonable period of time. If they don't get paid, they still have to pay you at some point. And then, of course, if it has neither of those types of clauses in it, then if it's net 30, they owe you in 30 days, regardless of whether they've gotten paid or not. Next thing you want to look at, one of the little hidden gems A lot of construction contracts will have a clause in there that allows you to ask for proof that they have sufficient funds or financing to pay their bills. It's a nice little tool to use if you're a GC and you have that vis-a-vis the owner, or you're a sub and you have that vis-a-vis the general contractor. Because sometimes it's a cash flow issue, sometimes it's a we don't have it at all and never will issue. It's not always just a straight, I don't like what you did here and I'm not going to pay you for it. Next thing, consider the impact of lien releases and lien waivers. Lien release is very different from a lien waiver. A waiver is something that you sign typically before at the time of entering the contract, and you're basically trying to get you to waive all your lien rights. A lien release is something you sign at the time you're submitting an application for payment, and you want to get paid. Avoid general releases. I put that in there because a lot of language in and around lien releases and waivers these days has general release language, which basically says that if you want to get paid, you have to release all claims up to the point of payment, whether it's related to payment or some other thing that's going on the project. That is not the intent of a lien release. Make sure you're reading your lien releases and that language is not getting stuck in there. If they want a lien release, that's okay, that's normal, but you're releasing to the extent of payment at that point. You're not releasing all other claims of liability. Change order approval process is another clause you want to look at. How are you supposed to get change orders approved, and how does that relate to when you can bill them and how you can bill them? And then you want to see if your contract has a provision in it that allows you to stop work if you're not getting paid. Oftentimes, there's a notice provision if that kind of language exists, and you got to say, well, if I don't get this overdue invoice in the next 2 weeks or whatever the notice period is, I'm going to stop work. So you want to start there in reviewing your contract. Liens and bonds. Construction liens apply to private projects. Keep in mind, if you do residential work, there's an extra statutory requirement in terms of what you have to do. It involves arbitration and some other notices. It's doable, but it's a little different than a commercial setting. Payment bond claims are primarily available for public projects. I am seeing them, as I said, on larger private jobs in recent years, but they are generally reserved for public work. Here's the municipal mechanics lien claim. They're a unique remedy provided by New Jersey. A lot of states don't have this remedy, and it is a right to lien on a public job, which is pretty rare. The difference here is you are not liening the real estate on which the job is being built, which is the case in a construction lien or in mechanics liens in other jurisdictions. What you're liening in New Jersey when you file a municipal mechanics lien claim is the project funds. So this is not typically available to the general contractor. It is available to people down the chain of privity. And it can be a pretty powerful tool, because what it does is you put the public entity on notice that you're not getting paid, and it freezes the account that has the money in it to pay the general contractor until that dispute is resolved. So you got to be a little bit careful about strategically when to use it and when to not, but it is a unique remedy that you do have in New Jersey and you don't have in some other states. Keep in mind that each of these remedies have notice requirements and timing elements. So if you think if you know you're not going to get paid, don't wait 6 months to make your decision about going to talk to somebody to get this done, because you don't have that much time. You got to give notices, and the timing of those notices dictate when you can file, and you have filing deadlines. So those range from anywhere from 30 days to 90 days to 120 days, and you just don't want to sleep on your rights, because these are powerful tools to have available to you. And when you look at your contracts before you sign them, don't waive these rights. Don't waive them, because they are very powerful tools, and anytime you are owed money, it's better to have more tools in your toolbox than less. Sounds like an obvious statement, but don't give up rights and remedies that you have available to you, because sometimes it's the payment bond company putting pressure on the owner and the general contractor, or whatever the case may be, that gets you paid. It's not necessarily the breach of contract action. Prompt pay statutes. New Jersey's prompt pay statute for private projects, it's not as helpful as some of the other states. It's not to say it doesn't exist, it just doesn't have as many teeth. So one of the tips I give clients is look at another state's prompt payment statute that you like, and there's nothing against writing the terms of that right into your own contract. So if you find a state that you like their prompt pay statute, just mirror that language and put it right in your contract, and you kind of create your own creative prompt pay statute. The Miller Act applies to federal public work and provides for payment of interest, penalties, and attorney's fees in certain circumstances if you're not getting paid. So that's a nice thing to have in your pocket if you do federal work. The standard in terms of what gets you those extra damages is usually some sort of a bad faith, showing of bad faith. Every state in the country, including New Jersey, has what we lawyers call little Miller Acts for state public work. They work very similar to the federal Miller Act. The last thing you're going to want to do is check your choice of law provisions in your contract, because if you have a contract, you're working in New Jersey, and let's say you're working for somebody who wants Nevada law to apply, well, arguably the Nevada prompt pay statute may apply, and that may be a statute that's of great value to you. Once you do that, go read that statute, because those statutes can have provisions in them about what applies and doesn't apply. So what I mean by that is, using Pennsylvania as an easy example, Pennsylvania's prompt pay statute, which is another state I work in, is a lot stronger than New Jersey's. However, it has a provision in it that says that in order for that statute to apply, the project where the work is being done has to be geographically situated in Pennsylvania. So you may have access to that by a choice of law, and then the statute takes it right away again. So it doesn't hurt to look, because you might be able to find something that works for you, but just be aware, don't just assume that the statute applies, because the statute, when you read it, may tell you it doesn't. And finally, some other practical considerations. We talked a little bit about making sure that the potential defendants are solvent. If you're suing a general contractor or an owner, they may or may not be solvent. If there's a payment bond and the surety's in the picture, they're probably solvent. In 20 plus years, I've only ever bumped into a situation where the surety wasn't solvent once. The litigation history of the adverse party. I would encourage you to do this before you sign the contract. But if you're dealing with an adverse party who has a long history of not only being in court arguing over contract balances, but not settling those and taking them all the way through to the end, that you should be hearing very expensive, lots of time, lots of frustration, and that's okay as long as you know what you're signing up for. Don't go into it blind thinking you're gonna be a big winner in 6 weeks, and then be 18 months down the road and sort of frustrated that it's not done. Just know what you're walking into. You got to evaluate your own resources and determine what you want to spend and how much time you want to spend. And you also want to consider, depending on the nature of the dispute, whether public exposure of the problem might create any issues for you. Sometimes if you're working on a high-profile job, for example, you may not want it out there that you got a little bit behind it and somebody owes you a lot of money. Maybe you don't care, but think about it. What are your personal risk tolerance levels? Some people are very risk averse when it comes to litigation. They'd rather not spend a whole lot of money and take a shot with a jury. Some people, just their attitude is, I know I'm owed the money. I'm willing to take that risk and roll the dice with the jury because I think they're going to like our story. So you want to sort of think through that. Next one, what does your documentation evidence look like? This is that issue, which is there's the story and then there's the story. And for those that have ever seen the movie A Few Good Men, there's a line in that movie that illustrates it perfectly, where the main character says, it doesn't matter what I believe, it only matters what I can prove. So if your evidence and your documentation of your claim isn't great, you may look at it very differently than if it is pretty good. So make sure you evaluate not just what happened, but can you prove it? And I would encourage you to start thinking about how to document your files well if you know there's a dispute coming, because oftentimes documenting your files well is the best way to avoid a dispute altogether. And then the last one that I have on this list, and this list is not dispositive, is are witnesses willing to help? Sometimes you get a third-party witness, for example, that you think is going to be the most helpful person in the world, and they put them on the stand and they kind of walk the line like, yeah. If they're not willing to testify and help you, there's not much you can do about that. And your case may not, in that instance, be as strong as you think. So that's the end of my presentation for this morning. There's the information for Rachel and the information for me. Thank you for taking 20, I guess it's been 25 minutes out of your day today to listen to what I have to say. And if you have any questions, I can take them now, or feel free to follow up. The floor is yours, Rachel.
Thank you so much, Josh, for educating us on this important topic. You provided us with super helpful, extremely valuable information, especially your slide on all the information regarding like reviewing your contracts. Those are some really, really great points of contract terms to consider. Let's see, we do have a question here. If you sign a lien release for payment and it is dated, does that release the GC from paying anything prior to that date on a later release? Does that release your rights to future claims?
So that's a very good question, and the answer is it's very fact sensitive. It depends on what the release says. So that's kind of what I was driving at with the don't sign a general release. And what I encourage people to do is take a look at your lien releases, and you should never agree to a lien release that is, unless it has language in it that says I'm only releasing payment claims to the extent that I actually get paid, and it only becomes effective when I get the check. Now, I've oversimplified the language, but you get the idea. So the answer is it depends. Maybe you'd have to really look at the language in the release to answer that question. I know that a lot of lien releases, when folks get them put in front of them, can be a little confusing that way because they are designed to release everything from the time you sign that release and it's dated going backwards. That's what they're designed to try to do. And so you want to be a little bit careful with those. It's right on point. That's kind of what I was driving at.
Okay, perfect. And I think that is our only question. Now, if you guys, oh wait, I think there's another one. Standard A1A release is what we use.
Yeah, so I will just say at the outset, not a big fan of standard releases, particularly the AIA forms. It's not that I'm anti-AIA or anti-architect. I think you just have to be realistic. The architect forms or AIA forms, they're written by architects, so they're going to benefit architects, and they're going to benefit the clients of architects, which are owners. So, they've gotten better over the years, but, no matter what the base form is, none of them have, I've not seen a one that regularly has all three of those categories that I described before in them, which is only payment claims, only to the extent I get paid, and only effective when I get my check. That last one is, if I remember correctly, is missing from the AIA form.
Okay, and I think that's it. Those are all the questions. So if you guys think of any other questions, even after the webinar, feel free to reach out to myself or Josh, and we'll make sure that we can answer any other questions you may have. I hope that everyone has a sunny day, and we hope to see you on our next webinar. Thanks so much, guys.